Justice Gorsuch.
Good morning, General. I want to follow up on your response to Justice Kagan, I think your second response, the level of generality question. Do you think the level of generality, I take your point, you've got surety laws, you've got affray laws, you've got a lot of historical evidence, maybe not the historical twin. And you're saying we should overlook that. In the same way, I think you would say, I want to make sure you'd say, the analysis also applies similarly to the right side of the ledger, the regulation side and the right side. We're not looking for, is it a Fowler or is it a Musket? Is that a fair understanding of how you see the law?
Yes, we think that it applies in both directions, both in understanding the right itself and in understanding the limitations that are built into that right.
Okay. And you had a discussion about the length of time that some of these orders last, and you emphasized that you're only arguing for a temporary dispossession. And I guess I'm wondering, on a facial challenge, do we need to get into any of that, right? Normally we ask on a facial challenge, is there any set of circumstances in which the dispossession would be lawful? And there may be an as-applied if it's a lifetime ban that would come to us, and that would be a separate question. Is that how you see it, too?
I agree that that would be a separate question, yes. I think that there is good reason to reject as-applied challenges if and when they come before the court because of the categorical judgments that we think history and tradition support. But I acknowledge that here it's only a facial challenge.
Okay. And along the same lines on the facial challenge aspect of it, do we need to resolve C2? And the questions that Justice Alito was asking, given that the defendant, the plaintiff before us, the respondent, is been adjudicated under C1, and we actually have a finding of a credible threat. The dangerousness argument seems most apparent there, and we don't know much about how all states administer C2 regimes.
So I agree that this is a facial challenge and the court could confine its analysis to C1. I guess I would make just two responses to that. Sure. One is to say that I think it's going to be difficult for the court to avoid the C2 issue. We ourselves have a pending petition where the Fifth Circuit has invalidated an application of the statute in a C2 context. So unless you want to see me here again next term on this issue.
Always delighted to see you, General.
The issue has been fully briefed and we think it's an important part of the statute. But the second thing I would say is that even if you wanted to confine your analysis to C1, I do think that at the very least you would have to reject some of the key premises of respondents' arguments in this case, and that relates to the colloquy I had with Justice Kagan. For example, the level of generality at which he's parsing the regulations, the fact that we don't have a domestic violence example in particular, his arguments that legislatures just can't disarm anybody, that persons can't be disarmed, that kind of thing.
All of that, gotcha. And the same thing goes with due process. We don't have a due process challenge before us, and so we don't need to resolve any of that either.
That's correct. He did not make a due process claim here. Okay.
And then lastly, some lower courts have recognized a duress defense to 922 charges. You know, someone's invaded their home and they use it in a gun that they have illegally in self-defense. What's the government's view on that?
So, you know, I want to be careful here because I haven't actually reviewed the cases that you must be referring to where those defenses have been made. I would have to take a look at those to provide you with a well-thought-out government view on that issue. Obviously, we recognize that there are distinctive legal doctrines like necessity and defense that can come into play. And so I'm sorry that I don't have
What would you counsel us to do about them? I know it's not fair standing at the podium not having reviewed them, but there are these historical common law defenses of necessity and duress when it's not aimed at the subject of the protective order, but a home invasion, for example.
So I would urge the court not to say anything about those doctrines here, where we've got a facial challenge and where certainly Mr. Rahimi isn't making that kind of defense to a Section 922G8 conviction. I would save for another day how the court might think about those issues where they're squarely presented.
Thank you very much.